Welcome back to Inside Politics. Our guest today is Ken Jost. He's one of the leading analysts of the Supreme Court. The U.S. Supreme Court's about to end its term, and we want to talk to him about the cases that are coming up and other things that are going on with the court. Ken, getting back to the case we were talking about right before the break with the LGBTQ community about this this adoption case going on in Pennsylvania, is the court's ruling broad enough that it's going to perhaps settle law about this, or are we going to have more lawsuits and more laws in states across the country as this issue continues to embroil itself across the nation?
The decision was 9-0, but it didn't settle the issue forever and ever. So Chief Justice Roberts crafted a limited decision that promises there will be more such cases, probably sooner rather than later.
Another unanimous decision by the Supreme Court found the NCAA in violation of the antitrust provisions of the law, allowing payers not to benefit, not to allow them to receive additional benefits beyond educational benefits while they're attending school or playing on the teams. Is this the end of amateurism? Is it the end of the NCAA?
Justice Kavanaugh, the only one of the justices who's ever worked as a basketball coach, wrote a concurring opinion and said, NCAA, we're coming after you again because your business model is just flatly illegal.
And now you've got a situation out there where some states have laws that have passed or take effect later this year that would allow college athletes to enter into agreements to receive money for their likenesses or endorsements. The NCAA is still trying to figure out exactly how to deal with that. Is that the next issue that Judge Kavanaugh can't wait to get back up to the court?
I guess so. And of course, in this specific case, the question was whether a college could give a student athlete scholarship money for grad school. And the NCAA wanted to prevent that, but the court told the NCAA to stick it.
There was a court decision late in the term that it may impact the First Amendment rights of free speech for students in terms of their dealing with their schools. This involved a cheerleader who put a very inappropriately worded, perhaps, text, and the school punished her, but she sued and got a unanimous decision from the court in her favor.
She got a unanimous decision in her favor. Doesn't settle every case. What the court said was that if a student off campus says something that the school doesn't like, generally the school can't punish that. But if the court left the door open just a little bit for instance, suppose that a student posts something on social media bullying another student. That might be grounds for discipline.
The court also made a ruling involving the patent system. This country's built on the genius of a lot of inventors. But based on the court's ruling, is Congress going to have to go back and sort of at least tweak, if not completely redo that patent system?
So the question is, how can the Patent and Trademark Office reconsider a patent previously issued that may be dubious, and this decision complicates a review procedure that Congress created 10 years ago.
Many situations involving the racial and social unrest in this country have been a part of police chases. The High Court, I think, issued a ruling that tried to clarify that, what officers must keep in mind when they do a pursuit after somebody onto their own home or property. Did the court's limits now in this impact how law enforcement officials are going to be able to do their job? Is it going to get so complicated they can't figure out whether to chase people or not?
So what happened in that case was that a highway patrolman followed a car for several miles into the driver's driveway and had no real reason to suspect a serious crime was afoot. And the trooper got out and walked onto, the driver's home and smelled alcohol on his breath and charged him with DUI. And the driver said, he had no business walking onto my property because, the Fourth Amendment, my home is my castle. And he had no grounds. And now the Supreme Court said that in a situation like that, generally, the police have to get a warrant if there's time to get one.
Ken Jost is our guest on Inside Politics. He's one of the leading analysts of the U.S. Supreme Court. He also began his career covering courts here in Nashville as a reporter for the Tennessean. Back to continue our conversation with Ken after this break.